Hey, I'm Mark Stevens, author of Government Indicted website, of course, markstevens.net. Got three success stories to discuss here on the big show today. 3 of them, baby. So what we'll do is we'll get to the first one, and 2 of the 3 have called into the show, so we do have some testimony and first-hand accounts reported to us on the big show. The first one we'll go to is Bill, and he called 1 or 2 shows back, and this is up in Ohio, and he did report to us that he did not enter a plea. So the judge is not accurate here, or the order is not accurate when it says the defendant entered a plea of not guilty to the charge. They didn't do that. They actually demurred or did a motion to dismiss, challenging the factual basis of the prosecution's claims that for personal and subject matter jurisdiction, in that to have jurisdiction, either one, both of them hinge on whether if the Constitution, a written instrument, actually applies to him and creates obligations just because he's physically in Ohio. They weren't able to do that. So he did file that motion, did challenge jurisdiction, and did seek discovery, including whether the witnesses that the prosecution relied on had personal knowledge of the matters they're testifying to, namely that the laws applied and he violated them. So what happened here, he was able to get it, he got it dismissed, the judge ordered it dismissed, and costs awarded to the state. So the plaintiff, or the accuser here, the government, the police officer, represented by a lawyer called the prosecutor, had costs awarded against them. So really, really nice there. So big congratulations. Even if it wasn't directly, it wasn't, the cause of this isn't because of the defense that he raised. What I'll make clear was with Mike and the 2 other ones I'll talk about in a moment, is that it's important to keep in mind that just challenging them is a win. And the fact that they were able to do this and get it thrown out without a lawyer, because a lawyer probably would have charged thousands of dollars to do what Mike was able to do on his own, and what any one of us are capable of doing on our own. And that is challenging the prosecution's accusations that they have facts and they have competent witnesses to support their allegations. So big congratulations to Mike. So we'll move on. We are going to go now to New York from Ohio. And Shane called, and we discussed this on the last show or so. And this is Angola, New York. And you can see here that it started as traffic, but it escalated to where he was charged with obstruction of government administration. Now that is usually that's usually a no-brainer. They'll throw the other ones out, but it's like, from what I've seen, it's like 100% of the time, if you are charged with obstruction, you're going to jail or you're being found guilty. So this is a pretty serious charge. As you can see here, the case captioned above was terminated in favor of the defendant. Nice. But what's also nice is we have a transcript of this, of what happened. So let's get to that transcript. There we go. So this is, of course, just part of the transcript, but because it was dismissed, it is very short. So the important part here is where the judge says, so we've been going back and forth with motions and appeals. And Shane had called it, yes, there was an appeal, and so I was mistaken that in New York, unlike some other place like Arizona, I believe, or California, the speedy trial does not, if there's an appeal or you ask for continuance, that it stops. It's not even a consideration. But here, that's not the case. In New York, if on the 3030, the speedy trial statute, pretrial motions and appeals, that's not calculated into it. So just because you take an appeal in New York does not mean the trial court is now exempt or accepted from the speedy trial. That still continues, but you can't add in pretrial motions and the appellate time, which makes sense. So he says here, I'll tell you what. In full satisfaction of all the pending motions, I'm to grant the defendant's motion on 3030. I'm just going to grant it, so those charges are dismissed. Now, there's a bit going on here. First of all, he testified, he reported on the show, Shane did not file a motion to dismiss on the 3030. He filed a motion to dismiss for a lack of evidence proving jurisdiction, and he filed a motion to dismiss for prosecutorial misconduct because the prosecution was arguing without evidence. That's why he dragged on for 2 years and went to an appeal. So the judge is wrong there. So there's already something, this is more than just meets the eye here. He says, in full satisfaction of all the pending motions. So it seems, he's not dismissing Shane's motions to dismiss, because he says, in full satisfaction of all the pending motions, I'm to grant the defendant's motion on the 3030. So no one can say with reasonable certainty or even with any consistency with the evidence that had nothing to do with the motion to dismiss challenging jurisdiction and that the prosecution was arguing without evidence. Well, the fact is the prosecution is arguing without evidence. We know that for a fact. Whether the judge accepted that, I think we can see here when it says in full satisfaction of all the pending motions, I think we can, he's not dismissing the other motions. He's not saying I'm denying all of the defendant's motions except for the motion on the 3030, which he didn't file. So here it seems pretty clear. And I'm sure, there are other explanations that are plausible, but this is pretty strong evidence here. Again, in full satisfaction of all of the pending motions, not denying the motions. So let's go. So big congratulations to Shane again, and thanks for allowing me to post this. And then we move to further north. We go to New Hampshire. And I want to thank Dan, good friend and supporter of the show, Dan in New Hampshire, up there in Littleton, for providing this. He is not the defendant, but you can see here that this is from the Littleton court in Grafton County. And according to Dan, that the reason given in this dismissal is not what actually happened. But I haven't heard back from him on that, so I'm going to go based on the actual document that we have. We do know that she was vigorously challenging the prosecution's claims, just like Mike and just like Shane, and that the prosecutors claim that here it's Matthew Favreau, that just because she's physically in New Hampshire, that the constitutional laws apply, gave him probable cause to do a stop and write a ticket, and that she had the laws applied and she violated them. Well, the judge comes down after the trial and dismisses everything. And this is just a speeding ticket. Article 15 of the New Hampshire Constitution provides no subject shall be held to answer for any crime or offense until the same is fully and plainly, substantially, and formally described to them, or be compelled to accuse or furnish evidence against themselves. The trooper testified that he stopped the defendant for speeding on Interstate 93. However, the complaint identifies the location of the offense as Main Street. The court finds that the complaint filed in this case does not fully and plainly describe the offense and does not adequately provide the accused with notice of the evidence that would be presented against her. As such, the complaint is dismissed. Now, to me, this looks like, according to what Dan relayed to me, that this is not what actually happened, that this was not why he threw it out in court. So, according to Dan, what is written here in the order is different than what was said at trial. So, it looks to be, even if this is true, it looks like it's just a harmless accident, a harmless mistake that I've seen that happen here in Arizona, where maybe the police officer saw the offense on Main Street, but when he stopped the defendant, it was on Interstate 93. I don't know. It could just be simply that Dan is dead wrong and that the judge is absolutely right here. The cop testified in open court to a different location than he put on the ticket, which would be a no-brainer to throw this whole thing out. But according to Dan, that is not what happened. So what I'm going to do is chalk this up to a good defense. Somebody did the right thing. Instead of hiring a lawyer or just paying the fine, she defended herself, did so effectively enough that she was able to get it thrown out. And again, that's the takeaway here. People should not be discouraged from fighting these tickets on their own. I'm not saying take on a murder trial or a robbery trial on your own, but when it's a garden variety code violation, the evidence is overwhelming. This is just 3 more out of hundreds that I've posted at markstevens.net where regular lay people we can go into court and we can effectively defend ourselves, and we don't have to mortgage our house. We don't have to sell a car or get a loan to be able to pay the fee of a lawyer, because we can and should be doing this ourselves. In a lot of cases that I've seen, even when someone takes a deal, they got at least as good a deal as a lawyer charging $5,000 would have gotten. So that's a big takeaway. But still, congratulations for standing up to these criminals in the traffic court. And bottom line here is, if they did have evidence to support their claim that just because you're physically in Ohio or New Hampshire or New York, that their constitutional laws applied and created obligations on us, they would just provide it. But there is none. Doesn't exist. But hey, if you disagree with me, there's 2 live broadcasts a week. You're more than welcome to call into a live show and present your argument and your evidence. I would love to see it. But again, congratulations to Mike, our friend Dan in New Hampshire, and Shane in New York. And thanks for allowing me to post this information. If you've got a question or concern or you got dissent, I'll call into a live broadcast and we'll hash it out. But hey, till then, salute.